To order.
All right, the record reflects we are back in session. Parties and counsel are present. All members of our jury and our alternates are present. And people may give your closing statement.
Thank you, Your Honor. Permission to use the well.
Sure.
Thank you. Good morning, ladies and gentlemen. How does a family of four disappear off the face of the earth? A mother, a father, and two young children. Just gone. Disappeared with no evidence of contact with another human being after February 4th. No bank or credit card activity after February 4th. No phone activity after February 4th. No internet activity. No email activity. Just gone. Off the face of the earth. Only to be found buried in two shallow graves in the Mojave Desert north of Victorville. 3 years, 9 months later. The only way that happens, ladies and gentlemen, is murder. Murder that you were just told by this judge is the taking of another human life by a person. An act that causes death. An intentional act called malice aforethought. That the person, when they killed, intended to kill. And that in this case was done willfully, deliberately, and with premeditation. That premeditation can be brief. It's the amount of reflection and the quality of the reflection, not the time. Ladies and gentlemen, what this case tells you, it shows you, is 4 counts of first-degree murder. There is no other reasonable conclusion to the evidence I'm about to discuss with you. One thing I need to point out to you, though, is that this crime is limited to those elements. It does not require us to prove where. It does not require us to prove when. And it does not require us to prove how. You can have a murder case without answering those questions. You can have a murder case without even a body. But here, ladies and gentlemen, this is 4 counts of first-degree murder. How do we know that? We look at the injuries to Summer McStay. Force sufficient to break a jaw. The injuries to Joseph McStay. Injuries forceful enough to shatter his skull. To little Joe Jr. to fracture his skull. And to Gianni to fracture his skull. Despite what precipitated the killing of whoever went first, whether it was an argument with Joseph over finances, whether it was Summer because of hatred over how he was treated, and the disagreements over raising kids, the fact that he believed she was a bitch, whatever precipitated the first killing ultimately won't matter. Because what will matter is you intentionally then killed 3 other people. He could have stopped. You don't need to kill Summer and those 2 kids. You don't need to kill those 2 kids unless you know that they can identify who the killer is. The killing of Summer and those kids and Joe was senseless. And it was violent. Violent with the use of a heavy object similar to the sledgehammer found in grave with Summer. It wasn't just one debilitating blow to incapacitate someone and remove them from the scene. It was blow after blow after blow to a child's skull. A 3-year-old and a 4-year-old That is an intentional killing. That is willful, deliberate, and premeditated. When you kill a 3- and 4-year-old who know who you are. By this man, the defendant, Charles Merritt. A man and a case motivated by greed and self-interest. Remember how Kathy Jarvis described him in that phone call and in that jail visit. Everything about this case from the defense perspective, greed and self-interest just permeated it. From the expert witnesses to the defense documentary team, to Kathy Jarvis looking to benefit from his acquittal, or even the defendant's benefit. That greed and self-interest motivated a man to kill a family of 4 and take them from this earth. He was a man with a means, a motive, and an opportunity. To understand the context of why a man so self-centered, so greedy, would kill someone and to kill 2 young children, you must have context to all the surrounding evidence. That context gives you understanding. You must look to the circumstances of everything that happened in this case to understand the who, the what, and the why. You can't just look at one thing in isolation. It is one big piece of collective evidence. You must look to the totality of circumstances surrounding the murders to understand the defendant's means, the defendant's motive, and the defendant's opportunity. Because remember, as the judge just instructed you, and I'm not going to belabor the point of showing you the whole instruction and reading it to you again, circumstantial and direct evidence is of equal weight. And you must accept only those that are reasonable conclusions and reject those that are unreasonable. And the reason I spend a moment talking about this, ladies and gentlemen, is not that I want to relive the cherry pie scenario from voir dire and little Gianni stealing a cherry pie. But the importance of that is what we learned, and hopefully you gleaned from that, and now the law the judge has given you, is that you cannot look at facts in isolation. A single individual fact may have 2 reasonable interpretations. One points to guilt, one points to innocence. And that isolated individual fact, in that scenario, you would have to accept the one that points to innocence. The problem is, ladies and gentlemen, when you're talking about the totality of a case that spans 6 months of your lives, almost 6 months, is you cannot look at those facts in isolation. One fact and how it is interpreted and what it means can be dictated by other pieces of evidence. Stuff that you may not have made those connections when you listened to them. Or you may have forgotten, given the fact that we've been here almost 6 months. The importance of a fact you heard from Michael or Susan on day 1 may not have had any significance or pointed to guilt until you heard facts from David Cicada or Carmen Garcia or Elva Fonseca. Weeks, almost a month later. That is why circumstantial evidence and understanding the law and how it interacts with the facts is important. You cannot isolate an individual fact just to say the person is presumed innocent. So, because we've been here for 5 months, I want to walk us back through the facts a little bit, actually in a lot of detail, to remind you of things that are important, but also to make those connections for you, to understand the significance and an interpretation of them that point towards the defendant being a willful, deliberate killer. So let's flash back a little bit. We heard from Michael and Susan that Joseph was running Earth-Inspired Products, a water feature company. But more importantly, we understood that this was a bifurcated business with internet sales I think Mike called them drop and ship sales, that came in through the internet website that was optimized by Dan Kavanaugh, really run by Dan Kavanaugh. And you actually saw evidence in this case, even through the defense case, that Dan Kavanaugh continued to run that business even after the murder of the McStays, with shipments to Adagio and other water feature companies. But then you had the other side, which was the custom orders. These are bigger, more complex, custom-built and designed waterfalls. You saw evidence from Joseph's computer of using a program to help design them. You've heard testimony ad infinitum about projects that were done, and these are custom installs. And these were done by the defendant. But what's more important about those is that you also learned that the defendant was being sidelined. And there were several pieces of operative evidence that you may not have connected those dots to understand it as the defendant being sidelined. One is there were project failures for Vecchio, Levine. You heard from David Cicada about having to make up work because the defendant wasn't doing it, or he was doing a sloppy job, or he was nowhere to be found. You heard from Susan and Michael, I think even MacGyver, if I recall correctly, that Joseph was looking for other fabricators and welders type people to do the work. You heard that Joseph was trying to consolidate the business and take more localized control over it. And you also understood from Fonseca and Cicada and Carmen Garcia that Joseph was aware of the problems with the defendant. So in the beginning, the McStays at the end of 2009 bought the house in Fallbrook on Avocado Vista Lane. And due to the timing of closing escrow and getting out of their house in San Clemente and moving into the Fallbrook house, there was some delay. So they moved in with Susan over in Temescal Canyon area into her home while she was living up in Ventura or Santa Barbara area. And then they eventually moved into the home in Fallbrook while most of their belongings remained in pods, those mobile storage units that you heard about, and that most of their furnishings and belongings were there. And what you understood from all of that, and when you connected all those dots and all those pictures you saw, was that they were virtually camping in the house. And that was evident on the 15th and the 19th when San Diego County Sheriff's Department went there. And you could see mattresses on the floor, clothing strewn about the house. It just didn't look lived in. There was no furniture. There was no dressers. There's no tables, except for the one in the dining room and the living room. So it didn't really look lived in. It looked camped in. Stuff just stacked into the garage. Surfboards, Christmas decorations, strollers, boxes of paperwork, painting supplies, you name it. But you also knew that they were beginning a remodeling effort. You knew that they were painting and replacing items, including painting the kitchen cabinets. There's the flooring that was brought in, is inside the front door. All of this gives context to what was leading up to February 1st, February 2nd, February 3rd and 4th, as we move into the disappearance. But we also know that they were preparing for Joe Jr.'s birthday. He had just turned 3, I believe it was, on January 31st, the day MacGyver was at the house. And found in the back of the Trooper in San Ysidro, hidden under a sheet, was a toy kitchen set and other little toys, trucks, and videos. Clearly, why would you hide that under a sheet in the back seat of the family car, other than so the kids don't see it? So we know on the 31st that MacGyver's at the house painting. Gave us a lot of detail about reminiscing with Joseph and Summer, the paint jobs that he had to do, the taping off, all of that gory detail. But the defendant was at the house that day. And what did MacGyver tell you about the defendant and the background relationship to Summer and Joe? He told you basically Summer did not like the defendant. That there clearly was some animosity between the two of them. And when he testified, he said this: there was tension in the air. He knew this was who Summer was talking about. She didn't even introduce us. If the tension in the air The animosity in the air is so thick for Mr. MacGyver to recognize it. It must have been very deep-seated and very strong. So he stays late on the 1st, or on the 31st, planned to return on the 1st, but he couldn't. I think you remember the exchange about his girlfriend had a doctor's appointment for the birth of their child. There was some text message. Summer was upset. Why was Summer so upset with him? Because she needed to get that project done because someone was coming to put the flooring in the first week of February. She wanted to get all that painting done so they could get the flooring done. Not unreasonable. But in a series of long textuses, there was a disagreement over whether he could return. But ultimately, he does return on February 2nd. So, we start moving into really important stuff that occurs in the 1st, 2nd, 4th, 5th, and 8th. 5th, 6th, and 8th. When you got all the collective evidence and you place it out into a timeline, you understand the importance of February 1st. And the importance of February 1st is not just the events, but you have to look at it in a circumstantial way of what would those events do to a person's state of mind. What state of mind would someone be in after receiving an email from your purported boss that says, you owe me $42,845? Most reasonable people, if they got a bill like that, would be pretty astonished. Chin would hit the floor. I owe how much? And it was outlined. Chase was overpaid, $15,000, plus Levine and the prevention disasters for a total of $42,000. That's what started February 1st. But then mysteriously, at 12:24 p.m., I believe that's correct, on Joseph's QuickBook account, Charles Merritt is added as a vendor. However, as you learn, the QuickBooks account was divided into 2 QuickBooks accounts. The internet side and the custom side. This was added to the custom side. Charles Merritt already existed as a vendor or a payee in the other side, properly capitalized. But at 12:24 p.m., it's added, but it's added in lowercase. I believe around the same time Metro Sheet Metal was added in the same fashion to that account. But then what also happens is a check is written. A check is written in the amount of $2,500 to that Charles Merritt with a vague lowercase description of deposit. It was created, it was edited, and it was printed. And then another check. Same thing was done. Created, edited, and printed for $2,500 to the lowercase Charles Merritt. However, there's no computer activity on the McStay computers that were recovered that would show that this activity actually occurred. Here's the other thing that's important about this. At 12:47 p.m. and 12:52 p.m., those 2 checks were deleted from the QuickBooks account. A habit and custom that did not exist for Joseph. In all of the testimony you've heard, there was only one other instance referred to where Joseph deleted a check. But if you recall, it was immediately reissued, and I believe it was to Metro Sheet Metal, if I recall the testimony correctly. These were just deleted, supposedly gone. Then we fast forward to February 2nd. Again, a series of events that the connection and meaning and understanding, standing alone, may not seem interesting or may not seem important. You have a series again of QuickBooks activities from 11:27 a.m. to 11:37 a.m. What we do know is on that day, February 2nd, MacGyver was at the house painting. We saw evidence of that in Deputy Tingley's photo. The drawers were removed, the cabinet doors were removed, there's paper on the ground. All consistent with MacGyver being there helping paint. No indication that the defendant was there on the 2nd. That QuickBooks activity was again to Charles Merritt, deposit SA 1001, but this was a zero amount. Again, created, edited, to be printed, deleted. But then you had a second check created. Same memo line, deposit for SA 1001, this time with an amount, $24.95. Again, to the lowercase Charles Merritt, and again, created, printed, and deleted. What's more important is, that check was actually cashed. That check was cashed by the defendant. What is interesting to note is there is no indication that the full deposits have been received for the Saudi Arabia project at this point, or that Joseph McStay actually created these checks to give to the defendant. In fact, the defendant was at home during that time, where there was a computer in the clubhouse that he could easily use. But again, checks that were created, printed, and deleted by a man who had never really done that before, that was not his business practice. Checks that could have been given to the defendant on the 31st when he was physically there, or potentially given to him at this mysterious meeting that may have occurred or may not have occurred on February 4th. But we know that the defendant got these because he cashed one of them. What you also know is that there was no computer activity on the McStay computers that were recovered from the residence. Why would Joe write 2 checks to the defendant on the same day? One handwritten, one computer generated. This $100 deposit, when you look at those bank records, is what opened the defendant's bank account when he deposited it. The defendant then negotiated the $2,400 check at or near that same time. If Joe was printing checks to the defendant, why didn't he print the $100 check? If Joe was printing a check for the defendant for $2,400, why didn't he just include the $100 to open an account? Why would only one be handwritten? Why would the printed check be in lowercase for a vendor that was just added on an account that you heard Joe never wrote a check from? Ever, until February 1st. Despite those QuickBooks accounts existing for years. Why is there no computer activity showing the creation of the printed checks? Why are the signatures different? Did you not catch, when you saw these exhibits, this signature on the $100 check is distinctly different than the check for $2,400? So, maybe there was an isolated, innocent explanation for the printed check. That it was the deposit for the Saudi Arabia project. Okay, that standing alone would point to innocence. However, when you put it all into context and answer all of those questions about all of the attendant circumstances on February 1st and 2nd, is that now a reasonable interpretation of that check? No. Why would those signatures be different? Better yet, why would they be written and deleted? Joe is attempting to run a business. He keeps a spreadsheet of his payments to the defendant and other vendors, project by project. He uses QuickBooks to monitor his checks, his payments to vendors. Why would they be deleted? So again, in isolation, that $2,500 check, $2,495, that check, standing alone, may have an innocent interpretation. But it's a deposit payment to the defendant for Saudi Arabia. Except for, you never heard any evidence of when that project started or whether he was entitled to a deposit. You also can't reconcile it with all of the other attendant circumstances. All of those attendant circumstances, including the deletion, point to it now being evidence of guilt, because that's the only reasonable interpretation. So we fast forward to the 4th. The 4th is a flurry of phone activity. This timeline boils down everything you saw in Exhibits 442, which I believe is Joseph's records, and 439, which is the defendant's records. And there's a flurry of phone calls. A lot of phone calls in the morning between Joseph and the defendant, back and forth. But what ultimately is important is this 1151 call to Union Bank of California, where Joseph had his bank account. We know that from the testimony as well as the phone number being consistent with the business card found in the checkbook. You also heard testimony that in reviewing those records, and you can review them for yourself if you so choose, that was the first time that a call to his bank ever showed up on his records. What precipitated that? Do I need to back up to a check being cashed? A check that was written on the 1st or 2nd, on the 2nd. So all of a sudden, Joseph has to call his bank. You have no direct evidence as to what transpired, but think about the attendant circumstances. You have now 2 checks written to the defendant, one that's been negotiated, they've been deleted from his QuickBooks account, he had already written him a handwritten check, but then in the middle, he calls the defendant and then again calls Union Bank. What necessitates a second call to Union Bank? A bank that you've never called before, according to your phone records. And again, there's no evidence that the defendant's phone activity is anywhere near Metro Sheet Metal that day, at that time. And what is also telling is that shortly after this call from Joseph, the defendant calls Jarvis, 1228, then to 1234. All of a sudden, the defendant calls the mother of children, Catherine Jarvis. And from that point on, you see Joseph from those phone records start internet access. The defendant's clearly in the area of his home because that's where his cell phone is pinging. Then at 12:52 begins a series of events that become important. Joseph calls a place called Walker Welding, according to those records. Why? Well, put it into context with what you heard from Mike and Susan and MacGyver, another fabricator. Then again, Joe's back on the internet a lot, all through the afternoon, all the way to 2:39 p.m. He's on his phone on the internet. But what's the defendant doing? The defendant is engaging in 19 phone calls back and forth with Catherine Jarvis. And then has to call Joe at 3:03 p.m. There is no evidence of activity again near Metro Sheet Metal on the defendant's phone or Joe's phone. But again, there's no credible evidence of a meeting either. Remember this theory that's being put forth by the defense, that Joe and the defendant met on the 4th. What is the only evidence you've heard that that allegedly happened? The defendant's statement. A defendant who's motivated by greed and self-interest. A defendant who is, after the fact, on February 17th, knowing what he did on the 4th, telling an investigator the events of the 4th, knowing that they would be important, because that's when they went missing, because he knows that. You have no credit card activity. You don't show any activity in the defendant's bank account or Joe's bank account, swiping for lunch at Chick-fil-A. There's no surveillance video. There's no independent witnesses that came in and testified, yep, I saw them there. You don't find a receipt in the trooper or the truck. The only thing you can rely upon to make that conclusion is the self-interested statement of the defendant. But think about it. Use your common sense. You go to meet a business partner or a colleague for lunch. Does that colleague spend the entire afternoon on the internet, on their phone? Maybe a 16, 17, 20-year-old millennial does, because they can't put the phones down. But you're talking more older business people. And this is 2010. This is not 2019 standards. Better yet, does one half of that meeting repeatedly call the mother of their children 19 times while you're having a face-to-face lunch business meeting? If that's the case, it's very rude. But look at that alleged meeting in context. There's another interpretation to this. That meeting occurred somewhere in this last 30 minutes of that afternoon. And that meeting was very quick. And that meeting was, I know you forged checks. I know you cashed that $2,500 check. I am done with you. I was already of the mindset of sidelining you and looking for other fabricators. I had already moved business to Metro Sheet Metal. I have already called Walker Welding. And now, the straw that breaks the camel back is you violated our friendship and our business relationship. You wrote checks from my QuickBooks account. You cashed them. You owe me $42,000 because of your mess up on the Levine and Provecho disasters.
Objection. Arguing facts not in evidence and has to admonish the jury.
That is a reasonable conclusion and inference that could be drawn from all of the evidence you've seen up to the 4th. It's circumstantial, sure. 6 of you could believe there was never a meeting based on that evidence. 6 of you could believe some other interpretation that there was a meeting, and then it was very short-lived in this time period. Those are all reasonable conclusions to be drawn. That's up to you to decide. Either way, they point towards the defendant, not towards innocence. They point towards the defendant in trouble. They point towards a defendant's state of mind that he owes $42,000. I've been caught cashing a check that I wasn't given properly and I forged. And now I'm in a meeting with my boss. Either way, it points to the defendant. Why did Joe go to Rancho to give checks to the defendant, if you want to believe that, when the defendant was in Fallbrook the previous days and was even given a handwritten check? Because remember, the defense theory is that there was this meeting on the 4th. And the defense has posited to you, both in his statement from February 17th and in the loose testimony of Catherine Jarvis here, that this meeting was for Joseph to talk about projects and give him checks. But why was that necessary if they had already met on the 31st, and I believe one of the other days in the beginning of February, and checks were actually given to the defendant, a check, a handwritten check. So why was there even a necessity for a meeting? Why would Joe have to give a defendant a blank check on the 4th when the checkbook was found in the car? If, in fact, he took the trooper to the meeting. There's one thing you must ask yourself. Does common sense tell you that, in fact, Joseph was the usual driver of the trooper? We may revisit this in a little bit, but think about it. You're married. You have a 4-year-old and a 3-year-old that sit in car seats. You have a wife who's very strong-willed, as everyone has testified to, and very opinionated. Is Joseph going to leave Summer at home with a car she can't transport those kids anywhere for over an hour or 2 hours or 3 hours? What husband in his right mind would do that? You never heard from Mike or Susan that in fact Joe was the usual driver of the trooper. You heard no such evidence. Again, you only heard that from the self-serving guilty conscience statement of the defendant from February 17th. And again, when you look at that statement and you use that fact, does it make sense in the context of all the other evidence you've seen? Or have not heard in that case? So as we continue on February 4th in sewing these facts together, you learn from Joseph's cell phone that he, by 3:07 p.m., has already headed back towards Fallbrook, where his phone is pinging on the towers going down the 15th. Again, there's another last-minute call from the defendant to Catherine Jarvis. Again, more internet activity, a text message to Summer, and then the crucial piece is the last activity of human contact that Joseph allegedly had with anyone on the face of this earth at 5:48 p.m. It was at that time there was a phone call between Joe and the defendant. No idea what that conversation entailed. We know how long it was. But what's also important is at that point, the defendant goes off the grid. The defendant doesn't just go off the grid. The defendant's cell phone activity disappears. As you heard testimony from Kevin Bowles and others, that is consistent with that phone being in airplane mode, or being powered off, or being out of signal range. You look at those phone records, they're replete with anywhere from Rancho to Fallbrook and never really falling off the grid like this. The only reasonable interpretation is that phone is powered off or in airplane mode. This is not bad cell reception. The defense is going to try to argue to you that, oh, these were missed calls, these were dropped calls. Remember all of this bad cell reception. That's not what that is. That is a phone that is off and every call being directed to voicemail. And that is 3.5 hours or more of opportunity for the defendant to go to Fallbrook, confront Joseph over this $42,000 debt, being sidelined in favor of Metro Sheet Metal and others. More than enough time to get to Fallbrook to confront Joseph. During that time, also, other activity occurs. Again, someone accesses the QuickBooks accounts and writes again another check to Charles Merritt, the lowercase account. It's added, attempted to be printed, and deleted. You're at evidence that it got caught up in the print spool and didn't print. But it was happened. You also know that there was internet activity or computer activity consistent with that on the computer in the house, the e-machines. So we know it happened in that house. During that time, the defendant's off the grid. During that time, Kathy Jarvis is repeatedly trying to call the defendant and figure out where he's at. We also know during that time period that a vehicle is seen leaving in front of the Mitchley house from what appears to be the McStay house and drives down the street. That all occurs in this time off period, this off the grid period. And the next time the defendant is located or has contact with other human beings is at 9:32 p.m. and his phone pings on a tower south of State Route 60 and east of the Interstate 15. Convenient? Could it be a flyer, as was implied by the defense in the cross-examination of Mr. Bowles? Possibly. In that isolated fact, that could be the reasonable interpretation. But you can't isolate that fact out to say, ooh, innocence. You have to look at it in context. You have to look at it in context that The defendant has a strong history of hitting those 3 towers around the Church Street address over and over and over and over again, even up to the 548 call. Never flying off of this tower. All of a sudden, he's off the grid for 3.5 hours. And the next time he hits the grid, he's not off of his towers near his home. He's south of town. He's south of the 10. He's south of the 60. A couple minutes more, you're at the 91. There is no evidence that this is a flyer when taken into context with the totality of the defendant's phone activity, the totality of his locations when he hits towers, and in context with the fact that he was just off the grid for 3.5 hours. Let's talk a little bit about that Mitchley video. You heard from Miss Mitchley. She came across, probably to you, very credible, very pleasant, very nice, seemed very cooperative, answered everyone's questions. But please take into context what the investigators in February were confronted with. That was not this Miss Mitchley, as described by Detective DeGaulle and others, was, no, she wasn't cooperative. She wouldn't give us the DVR, right? And, judges were telling us we didn't have enough for a search warrant because we don't have a crime, a felony, so I can't just go in and take it. And they were stuck with what she gave them. She dictated what evidence existed in this case, not the detectives. So if there was confirmation bias at all in that part of the investigation, it was Miss Mitchley. Nonetheless, that's context. That gives meaning and importance to this evidence. Nonetheless, you get this video that shows the vehicle leave, make a turning movement, drive down the street, and hit the brakes. Is that vehicle choosing to park across the street just down from the Mitchley house? Possibly. Is the driver of that call checking his or her cell phone as they leave the residence? Possibly. But again, isolated facts need to be looked at in its broader context. The shadow left by that vehicle has distinct characteristics. But more importantly, think about what Miss Mitchley said. Quiet neighborhood. Except for that night. Probably caught everyone by a little by surprise when she was asked why the quality of this grainy black and white video changed somewhere in the middle of that footage. It got a little clearer in this segment, a little brighter in this segment. You didn't see the cobwebs or whatever it was floating around. Why? Oh, I remember. I heard something. I heard a noise. And I went to the front and I turned my porch light on to see what it was. That's pretty significant. Something happened in that neighborhood on February 4th, prior to this vehicle leaving the McStay residence. Something that was loud enough for a person inside their home on a winter's night to be alerted to it. Something loud enough and disturbing enough in a quiet neighborhood for Miss Mitchley to go to her front door and turn on the front porch light to see what was going on. And again, those unique characteristics, the low-hanging tailpipe on the right-hand side of the vehicle, the possible electrical box on the front of the vehicle. To help give context and meaning of this, you heard from Eugene Liscio, a photogrammetry and 3D forensic reconstruction expert from Canada. I will note for you, by the way, in Exhibit 796, the glow and the bleed out in that photograph, even though it's taken 4 years later with a better camera at a closer angle, those lights are all washed out, including the parking lights. So, what Eugene told you, what Mr. Liscio told you, is that's not the side light, the side marker light from the defendant's truck. That its height was inconsistent with that being the light. He pointed to several different things. He showed you that it disappeared, and he showed you that it changes intensity as it moves. In fact, you heard, even with Mr. Stutchman, the defense witness, that it changed for 4 frames. And you see how it gets brighter as it moves closer to the Mitchley porch. What is it? No one really knows, given the quality and character of the video. It's not the best video, granted. But it was more consistent with the side latch and some type of reflection off the side latch. The defense will probably tell you, oh, it's not chrome, it wouldn't reflect light, it's too intense. So that's a lot of speculation. But the one thing I point you to is during Liscio's presentation, remember he pointed out the water valve cover in the middle of the street, laying in the street, it's like steel or whatever it was? As the headlights hit it, it has a reflection. The yellow fire hydrant had a reflection in this video. So you don't have to be chrome. What you probably have to be is out of position to be able to catch the light, such as slightly open or ajar. And you heard testimony from Mr. Liscio, and I believe maybe even Sergeant Smith, and in fact, that lever, that particular one, was very difficult to manipulate. Granted, when they inspected it 4 years later. But then you have the headlight comparison. So Mr. Liscio takes these headlights that are washed out in this black and white grainy video. He tells you, you cannot see the actual headlight due to the quality of the video. So what he did was, he drew circles or ellipses around the glow that is in the washout of the video to give its approximate location, as he's showing you in this clip from Exhibit 976. But more importantly, what he does is he gets correspondence of what he's done with that modeling to show that it's consistent throughout the video, that those ellipses track the vehicle as it moves and is consistent with the angle of those headlights as it moves. He then inserted the 3D model of the truck to show that same consistency, that those ellipses followed that movement. And he shows you frame by frame how that occurs. But then he moved on from that and he even showed you there would appear to be this strange glare, which was possibly from the top of the bumpers caused by the projection of the lights. So he goes, I wonder if those are consistent with the modeling. And so he does his experiment, as shown here in this excerpt from 976. You can see, even when he zooms in on the video, how pixelated and washed out those headlights get to where you can't even see the definition of them. he even overlays the neighborhood Faro scan to his modeling that he does to show that there's correspondence with the level of the street. He even goes underneath the street to show that those lines, those projections, those modeling do not penetrate the asphalt, to show that consistency. He then showed you how the unique shadow on the back of the truck, when seen in the Faro, with the lights on, with the brake lights depressed, created a unique shadow, and how he modeled that shadow for comparison to the evidence video. And again, he walked you visually through every step of his modeling to show you how he created it, how he made measurements, how he outlined certain shadows, to show the consistency of his work step by step. He then took that and overlaid it into the evidence video, what we've called the Mitchley video. And you see in this excerpt from 976, he inserts the model, and then he inserts the shadow trace that he did. And he shows you the consistency of that shadow with the unique characteristics of the defendant's truck. And what's more important, really, about that shadow, it's not the quality and character of it in the evidence video. It's its shape. It's its shape construed by the curb. It's its shape construed by the brake lights being applied. And it is its uniqueness based on the rear end characteristics of the defendant's truck. Those unique class characteristics, that box, that trailer hitch, the shape of the bumper, Mr. Liscio even showed you how that shape is construed and manipulated by the shape of the curb, and how that shadow is consistent with placement of the truck in the model, parallel to the curb and the gutter in a normal driving situation and actually on its surface. Again, walking you through his steps to show you the correspondence of the evidence. More importantly, you remember those unique class characteristics and how if they change the shape of that shadow. Should that box, whatever it is, or the bumper, or the hitch, or the position of the light, change position in any way, it affected the shape and uniqueness of that shadow, which would affect its shape in comparison with the evidence video. Remember, when you talk about the side latch, illumination, whatever that is, the uniqueness of the shadow and the positioning of the truck and that shadow, they're dictated in that evidence video by what piece of evidence? The application of the brake lights at that time, at the very end of that video clip. Remember, when you saw the truck as well as the evidence you heard from the stand, the housings around those brake lights had an open, translucent area to them. Well, if it's open or translucent, it would allow more light through, making it brighter, causing the effect that you would see in the shadow on the street. But also there was the exhaust pipe comparison. where he showed you frame by frame the comparison of the model from the Faro scan to the evidence video. And then how it tracked in every frame you saw it and was consistent with that model. And I'm actually going to skip to the next clip because it actually is more convincing. And I thank Mr. McGee for asking him this on cross. You turn on the model, you turn on the exhaust pipe, and it matches even the pixelation zoomed in. Frame by frame, track by track. So remember, the context in which to analyze the Mitchell video is one that takes into consideration it's at night, it's from a distance, because it's in black and white and the quality of the camera, everything kind of gets washed out on the front end, it's hard to see, can't even see the direct headlights, and how it is then analyzed, both using a 3D model overlay situation and finding points of comparison that line up with and are consistent with it being the defendant's truck. So I must at this point comment on the fact that you also heard evidence from Lenny Rudin. This was an expert with an agenda from the minute he hit the stand. Almost the first question and answer out of his mouth, you could tell he was upset that some other expert came in and did work and it wasn't him. Didn't use his software, didn't use his methods. So he's so upset about it, he reaches out to the defense. And what was his agenda? The first thing out of his mouth here was, he had an agenda to do a live reprojection. And it wasn't done in the middle of trial. It was not done. Okay. But why was it so important to him? And he told you, if it worked, I could retire. I want to do this so I can make money off it and I can retire. I could end my career on a high note. More importantly, think about the quality and character of his testimony. His recollection and his explanations were blurry and fuzzy. Were probably blurrier and fuzzier than the evidence video. He's here on day one, is asked a whole bunch of questions by Mr. McGee, and on day two, he can't even remember what he said the day before. He couldn't even remember when he said that in analyzing the trooper, the image, I got to try and get it right, the image changed, or the image shape changed, whatever it was. Remember, he was confronted with that. He couldn't remember saying that. Because he could not concede that his program and his algorithm would manipulate the projected model into a shape that was not consistent with the actual model. Better yet, he used, during most of his analysis, the side light, not the latch. It wasn't until he went home after the first day, and it sounded like from the back and forth of the questioning that Mr. McGee asked him to figure it out, that he figured out this trajectory of the side latch through the video being consistent. Lo and behold, shocking, Mr. Liscio was right. It must have been the side latch causing some type of reflection because it's consistent through the video and it's consistent with the location of the side latch. Okay? But he wouldn't stop working. That latch is consistent even in his experiment. But more importantly, all of the work he did on the case, when he would go into the evidence video and the model, and he would select data points, pixels, whatever points it was, they all still matched when he overlaid them and he went through his magical computer algorithm. Whether he did it as 4 points back many years ago for the sheriff's department, or he did 5, 6, 7, 8, 9, 10, however many he did, they all matched. You saw the 10-point match. All those data points still lined up. But remember, his methods themselves introduced a level of error that would affect the ultimate margin of error or acceptable error of this case in his analysis. And it was something as simple as where he began. He selected the data points. He selected which data points in the evidence video should try to match up with the model. He introduced his own error that ultimately could not be validated. That subjective margin of error, by the way, that he can change. He can change the margin of error because what did he tell you? It was a process I dreamt up. It was a process that's never been used before, never been validated before, never been used by others for validation. He didn't send his work off to be validated by others. And from day one to the day he finally testified, the margin of errors moved. It moved from 5% or 6% up to 10%, and then ultimately when he testifies back to 9%. When you have a subjective margin of error, what does that mean when you make an error in your own data selection points? He could not validate any of his own experiments, including the measurement experiment. He had to write a white paper on it and send it off to others, which we still haven't heard the results of. But the problem with that, he's trying to force hard geometry into a low-quality headlight glow for data points that he manually selects. Data points that he could introduce error with. And when you try to take something like hard geometry, that a squared plus b squared should equal c squared on a triangle, and you put it into something low quality, pixelated, washed out, and a human has to then figure out the data points, you inject error. Even the defense's own witness, Mr. Stutzman, said Lenny's work was flawed. He tried to attribute it to the sheriff's department. Maybe he unwittingly didn't realize that it was his, idol, Mr. Rudin, who had done that work. He seemed quite embarrassed when he testified to that. But what's the importance of this? The importance of this is to convey to you, from the defense, a belief or a theory that the people have not proved that the defendant was in Fallbrook on February 4th when the McStays are last heard from and disappear from the face of the earth. Again, you must take it all in connection with all of the other evidence. Because remember, Dr. Rudin even said the actual measurements of the truck are unknown in the suspect video. So if the actual measurements of the truck in the suspect video are unknown, how are you forcing that hard geometry measurement of the truck into that unknown and trying to make it match? It doesn't make sense. The other line of theory is, we can put forth to you Catherine Jarvis to say, he was at home. But it's a failed alibi witness. Ultimately, in the end, she never told you he was at home or gave you any corroborative evidence to establish, in fact, the defendant was at home on February 4th, despite her valiant efforts. Remember, in that testimony and the recordings that you heard with Jarvis, that the defendant had pissed everyone off, that this would never have happened if you were a different person. And it went from, he was home, rock solid, I know he was home on direct examination with the defense, to, he must have been around. That doesn't seem very credible from a witness that clearly has a bias. a witness who potentially profits off the defense documentary film if her story's believed and he's acquitted.
Objection.
If I was calling him,
Objection. Argues facts not in evidence as to admonish counsel.
Ms. Jarvis testified on cross-examination with Ms. Rodriguez, and you can review the transcript. When she asked her if she was aware of it, had been interviewed by it, and would potentially, because he has not gotten child support in the last 4 years, potentially receive monetary finances from that.
Objection, Your Honor. And I think we need to approach now.
Overruled.
And I ask that the counsel and jury be admonished.
The objection's overruled. Again, ladies and gentlemen, you, as I indicated to you, the statements of the attorneys are not evidence. The attorneys can give you what they believe the evidence is and what they believe are reasonable inferences and conclusions to be drawn from the evidence, but ultimately it's up to you to decide what the actual evidence is and what the reasonable inferences and conclusions from the evidence is.
And you're free to review Ms. Jarvis's testimony at your leisure to see that conversation. If I was calling him, he must have not have been home when confronted by Ms. Rodriguez on cross-examination about all of these calls going to voicemail. Well, wait a minute. That's not, he was home. That's not, well, maybe. He must have been home. It went from, I saw he had 3 blank checks from Joseph to, well, I don't know. I didn't see them. Because she was coached by the defendant. Why does her testimony fall apart about the 4th? Because she was coached by the defendant. Quote, these are the things we need you to remember. Okay, now you know, because you're going to be asked about those specific things. A witness who has to be coached by the defendant to remember the most important day of a murderer's life shouldn't have to be coached. Especially when it's a family member and mother to his children. And should be able to give us something more than, well, maybe. But here's the important thing about the 4th, ladies and gentlemen. Everything I've talked about with the timeline, the computer activity, the phone activity, the alleged meeting, all of that in context. Sure, could there be one or more of those pieces of evidence that has a reasonable interpretation that points to innocence? Maybe. However, when you take them in the full context of all of the evidence of the 4th, those reasonable explanations go away and they turn to only reasonable explanations of guilt that the defendant killed a family of 4. Because, I'm sorry, I forgot, Ms. Jarvis spent 8 hours with defense counsel. Because he told her, and because all of those facts about the 4th are not some random coincidences. In order for you to believe that the defendant was not there on the 4th and committing 4 willful, deliberate, premeditated murders, you have to ignore other evidence. You have to ignore the checks that were forged to the defendant and deleted from the QuickBooks account to a vendor that never existed before in that account. Didn't happen, but they did. And the only person to benefit from that was the defendant. You would also have to ignore the fact that Joe, for the first time, calls his bank. And in relation to other evidence, such as the check being deposited and negotiated. A bank he's never called on his phone, according to his phone records before. You would have to believe that there was this alleged meeting, even though it's inconsistent with them being together earlier, giving a handwritten check earlier, the fact that Joe spends the entire afternoon on his internet, on his phone, the fact that the defendant allegedly during this meeting is calling his mother of his children, Catherine Jarvis, 19 times. You would have to ignore the fact that the defendant was off the grid. That his phone was off the grid for 3.5 hours. And neither Taylor nor Catherine tell you exactly where he's at. They tell you where he may have been. You would have to ignore the fact that his first human contact via cell phone at 9:32 p.m. is not at home and is not on those towers he hit time after time after time after time and again over months when he was at home. You would have to ignore the fact that those checks were written to the lowercase Charles Merritt and negotiated by the defendant into his account. You would also have to ignore the fact that those checks were deleted in an attempt to cover their tracks. You'd have to ignore that to find that he wasn't there on the 4th. You would have to ignore the fact that Mitchell heard some strange noise for her neighborhood, causing her to go look out the window, turn on the light to see what was going on. You would have to ignore this mysterious truck that just coincidentally has a series of unique characteristics consistent with the defendant's truck is leaving the driveway right around the time that all of this happens. These are not random coincidences, ladies and gentlemen. They're facts. They're evidence. And when you look at them in their totality, it shows that it was the defendant at the McStay house that night. Why? Because he owes $42,000. He forged checks. He's being sidelined. He's not going to let that happen. Because he's a greedy, self-centered, self-interested man. And then we'll talk about more motive as we go along. But up to this point, that's what you know about a defendant's state of mind. So after these random coincidences, and I use that facetiously, occur, you then have to get to other evidence. So let's talk about February 5th. February 5th, again, no activity from the McStays, no human contact with the McStays, no phone activity, no internet activity, nothing. Dropped off the face of the earth. All around 12 p.m. to 12:39 p.m., a series of QuickBook activity occurs. A series of QuickBook activity not on the McStay computers. A series of QuickBook activity of which checks were created, edited, printed, and deleted. And checks that were ultimately negotiated by the defendant. You have your first transaction for Paul Mitchell, all in lowercase, for $4,500. Created, edited, printed, deleted. What was edited? They were backdated to the 4th. Why would Joseph backdate a check to the 4th if he did this on this mysterious Giuseppe laptop that there's no evidence of? Why would he delete it from his own QuickBook records if he's paying the defendant $4,500 for a Paul Mitchell job? Why would he backdate it to the 4th if he's writing it on the 5th? By the way, negotiated by the defendant. Again, all in lowercase. All again, a signature that doesn't seem to match up. Then you have the second check. Miscellaneous manufacture, $1,650 to Metro Sheet Metal. Remember, all lowercase, added at the same time as Charles Merritt. This one was miscellaneous manufacture. When you go through those physical checks that we gave you as exhibits and that were testified to, both handwritten and computer generated, you do not see things such as miscellaneous manufacture. You see Paul Mitchell. You see Levine. You see other projects. You don't see miscellaneous manufacture. Again, created, edited, and deleted. Again, created to a fictitious vendor that was added, that is inconsistent with Joseph's business practice, edited to backdate to the 4th, and then deleted, and then negotiated. Another check to Metro Sheet Metal for copper, $250. Again, created, edited by backdating it to the 4th, and deleted. And again, for copper, something inconsistent with Joe's custom and habit as seen by the other checks he's written. You then have another one to the defendant for lighting install SA 1001 2350. Added, edited to backdate to the 4th, and deleted. And negotiated by the defendant. For a project, for all intents and purposes, we can tell from all of the evidence that was garnered in this trial, hadn't even started yet. Another check, 6505. The balance of SA 1001, again to Charles Merritt, all in lowercase. Again, added, edited to backdate to the 4th, and then deleted. Wait a minute. Let's assume there's an inference from the evidence that the Saudi Arabia project had somehow started. Just even in its infantile stage. Why would Joe be writing him a check for the balance when that project hasn't been completed and there's no evidence of final payment or install? Why would he be getting the balance on the same day as a deposit? That doesn't make sense. That doesn't reconcile with his spreadsheet. It doesn't reconcile with the rest of his QuickBook activity. And even if there is an innocent explanation for this, there is no evidence that Joe's business practice was to create, backdate checks, and then delete them from his QuickBooks account. The importance of that, of backdating them to the 4th, is what? The author knows that the last human contact with Joseph McStay was February 4th. Otherwise, you could pick any day you wanted. You could have picked the 5th, could have picked January 31st, could have picked whatever. But the operator mind is the person who's benefiting from them and cashing them, is the person who's writing them, and their frame of mind is that he knows that Joe's last contact with other humans is February 4th. And all during that time, the defendant's phone activity is around his house, and then he goes off the grid again. He goes off the grid from 3:54 p.m. to 9:17 p.m., after which he is then seen pinging towers in a northerly direction on the Interstate 15. Where was the defendant for almost 6 hours? What could the defendant do in 6 hours? Clean up a crime scene? Hide evidence? Move evidence? That's 6 hours of time. You've seen no evidence of transactions in his banking records, that he was sitting at some casino. You've heard from no witnesses that said, oh, I was sitting next to him at the casino. You did not even hear evidence from Kathy or Taylor that he was sitting at the clubhouse watching a movie or having dinner with them. They didn't mention that at all in their testimony. Huh. Wonder why that never came up. Doesn't fit the narrative? And again, when you look at his phone records, there's no activity for the defendant in or around Metro Sheet Metal on that day. That takes us to February 6th. After being off the grid, since his last contact at 9:25 p.m. on 2/5, his first contact is at 10:45 a.m. And all of a sudden, at 11:30 to 11:52 and 1:30, the defendant's phone is pinging off a tower on Quartz Mountain. in north of Victorville off of Stoddard Wells Road. Or I'm sorry, Dale Evans, Stoddard Wells, north of the dump. You took a field trip out there. You probably didn't know it at the time. Then one of the significant things about seeing that remote location was not only its access points, the condition of that desert, the location of the graves, heck, the tire depressions that were still there. You probably didn't think, when you were standing at those graves, to turn around 180 degrees and look at that big mountain behind you and see the cell phone towers on top of that mountain, within eyesight of those graves. Within eyesight of those graves, the defendant's phone is pinging. And important is one of those or two of those calls in particular, where it pings off the sector of that tower that points due east. Not south into the town of Victorville, not southeast into the town of Apple Valley, due east, not north towards Barstow, due east. Not to the west. Oop. Sorry. There was audio there for you.
I don't recollect being there. Matter of fact, I wasn't there. I definitely wasn't at the desert. And I don't know what to say other than that.
I wasn't in the desert. Despite his phone records logging 6 cell site hits in the desert. And then he goes off the grid again from 3:14 p.m. to 10:35 a.m. 6 hours again, give or take. Almost 7. That's right, 7 and some change. Well, 7 and some change. Actually, even more than that. 17 and some change. 17 hours in which a defendant, a murderer, could move evidence, hide evidence, clean up evidence. But what's more important about the 6th? The fact that you heard in opening statement that some fancy Russian cell expert named Vlad was going to come debunk all of this evidence, but you never heard from? No. What's important of whether or not it hit this sector versus that sector versus how long? Not really. You heard from the defendant who said, I wasn't there. But it's important to have an alibi for the 4th, but what about the 6th? Neither Taylor nor Kathy testified of where his whereabouts were on the 6th. His sister testified, doesn't put him in the desert on the 6th. In fact, what you heard is that his sister lives right where that red triangle is. Sorry. About 8 miles due east. What's probably important is that his cell phone never hit a sector pointing towards his sister's house. Better yet, his brother, you heard, lives in Hesperia, Bennett. Defense didn't call him to put him there on the 6th. So why would the defendant be there on the 6th? What other circumstances about this case where the defendant, when he's interviewed by San Bernardino in 2014, knows where the bodies are located, knows where they're discovered, knows his whereabouts, finds it important to lie to investigators and say, I was not in the desert on the 6th? Because the evidence would point to someone associated with the killing of the McStays was in the desert on the 6th. February 8th, we have the weird 2 a.m. internet searches on e-machines for QuickBooks, followed by random searches through the Google toolbar to push them down. Was it effective? No, we still see it. But for someone who may not be computer savvy, maybe thought he pushed it down enough, It shows that it wasn't the last thing searched. Maybe when that was done, it was simply to bury it a little bit to show it wasn't the last thing done. More importantly, where was the defendant at the time? We don't know. His cell phone doesn't tell us. Kathy doesn't tell us. Taylor doesn't tell us. You have a gap from 5:17 p.m. until 7:30 a.m., 7:26 a.m. the next morning. No cell phone activity. No witnesses putting him at home. On February 8th, that day after those internet searches, the defendant all of a sudden at 7:26 calls Catherine, and then there is no phone activity reflected in his cell phone for 5 hours, 8 minutes. Where was he? Don't know. We know he's off the grid because then there's one of those calls again that went straight to voicemail. The defendant's off the grid again for a period of 5 hours, 8 minutes. But then what we have is a series again of QuickBooks activity that occurs right in the middle of the day from about 2:20 p.m. to about 3:51 p.m. And what was important in there, cell phone records, is that checks were again created. All of a sudden, a check to Charles Merritt for Saudi Arabia Final for $6,500 is created, edited, backdated to the 4th, and then deleted after being printed. Okay? Why would Joseph or whoever be giving a check to the defendant for Saudi Arabia Final when there's no evidence that final payment's been made? There's even no evidence that it's been built yet. When, oh, by the way, a check was written on the 5th for the deposit. So in a matter of 3 days, we went from deposit to final. I don't think Mr. Cicada's opinion of the defendant's construction abilities included being able to build this really fancy, really big Saudi Arabia project in 3 days. There's no evidence to that. Matter of fact, those reasonable explanations pointing towards innocence fall away when you look at the checks for the 8th in context with the checks for the 5th. They make no sense. They do not reconcile with something that points to innocence. They reconcile solely with the defendant, Charles Merritt, forging checks to financially benefit from a missing Joseph McStay. And then again, negotiated that check. Again, even if you believe that for some reason the defendant isn't the one that created the check, he's the one that profited from it. It went into his account. Again, you can only conclude from that. The only reasonable conclusion is this: the defendant creating them, printing them, editing them, deleting them. But what's also important there? At 2:44, there's the phone call to QuickBooks or Intuit. I'm sorry, strike that. There's an online activity to Intuit QuickBooks to cancel QuickBooks. And then all of a sudden, someone goes back in and logs in and goes, oh, wait, I can create more checks, and wait, there's more info there. It didn't go away when I canceled it. So then at 3:11, there's a call to QuickBooks, Intuit. I want to cancel. I want to cancel QuickBooks, a program that I've used, if you're Joseph McStay, for years to track his business. How does that make sense other than it's the defendant doing it, considering those calls to QuickBooks came from the defendant's phone? The only reasonable interpretation of that is he tried to cancel it online, realized, oh crud, it didn't work. It doesn't delete the information. The account's still there because, as you were told, it was saved in the cloud. So he calls QuickBooks about, hey, I need to cancel this. I need to get rid of it. I need to put it on a desktop where no one can find it. And during that activity, where's the defendant? At home, presumably, given his cell phone activity. But important is, at 6:31 p.m. is the last phone call registered on the defendant's phone. That last phone call is the last time he's heard from on the 8th. The next time you hear from him is at 7:34 a.m. on the 9th. You're talking almost 12 hours of inactivity, almost 13 hours of inactivity, from 6:31 to 7:34. Time to move evidence, conceal evidence, clean up evidence. And it's during that time, ladies and gentlemen, during that long period of time, by the way, there was no evidence of metro sheet metal activity around that time. It's during that time, ladies and gentlemen, that the trooper was noted at 9:18 p.m. in the San Ysidro parking lot by the security guards working for Bruce Carter. It is during that time, that long period of time, in which the tow was authorized at 9:19 and then was ultimately towed and closed out at 11:05 p.m. A lot of time on February 8th for the defendant to move evidence, clean evidence, hide evidence. All day long, really, except for the short time he's writing checks to himself to profit from the disappearance of Joseph McStay. Here's some things you may not look at or may have missed in the context of the trooper. It's located in the San Ysidro lot where people commonly will park their cars in order to go across the border. Look at that picture taken by the security guards. Granted, February, San Diego is probably a little damp and a little cold, but you can tell from that vehicle that it's already building frost. But it's not completely frosted over, right? What kind of day was it? There's no damage to the vehicle. Right? That vehicle was placed there sometime that day. The importance of that is the fact that the security guards cannot tell you when. They had two separate properties they had to patrol. You can tell they didn't take really good notes necessarily about anything. They didn't have a clear recollection of anything. You just don't know. Could it have been there in the morning and they missed it? Sure. Could it have been there in the evening and they missed it? Sure. Could it have been put there at 7:31 p.m.? Sure. Regardless, the only time on February 8th that the defendant is known whereabouts is while he is forging checks to profit off the disappearance of Mr. McStay. And that takes us to February 9th. February 9th at 7:34 a.m. is the first phone activity for the defendant since 6:31 the night before. And it's immediately at 8:06 a.m. that there is a call to QuickBooks, logging his telephone number, asking to delete the account. And remember Ryan Baker's testimony, it needs to be deleted. Why would Joseph McStay or someone with innocent intent need to delete the business records for a business that's been around for years? There is no reasonable evidence based on reason for a defendant needing to delete QuickBooks and order a new one. No reason based on the evidence at all. Joseph could have gone to the store and bought the desktop version. You would have to believe, by the way, that Joseph was not attentive enough to change his shipping address when he ordered it from San Clemente to Fallbrook. By the way, up to this point, up to February 9th, when the defendant's phone and whoever's on it calls QuickBooks to completely delete and obliterate this account, the defendant has done nothing, absolutely nothing to find Joseph. A business partner he was best friends with, a business partner that he had numerous contacts with all day long. Joseph's now been off the grid for more than 5 days. The defendant has forged checks that he has cashed for projects that haven't even started or haven't even been finished. He has done nothing to find Joseph. That is until Carmen Garcia alerts him to Joe being missing. Uh-oh, someone knows Joe's missing. Someone can't get a hold of Joe. Again, perspective, the defendant's perspective. Were family members not knowing where Joe was? Sure, there's evidence of that. Were probably other business entities not knowing where Joe is? Sure, there's evidence of that. But all of a sudden, this is the first person to put it right in the defendant's face. Joe's missing. We can't get a hold of Joe. Oop. Let's see. There is no coincidence to this QuickBooks activity, ladies and gentlemen. None whatsoever. The only innocent explanation requires you to believe Joe was changing his entire business practice overnight and giving control to a person he was clearly not trusting and attempting to sideline. Is that a reasonable interpretation to that QuickBooks activity? No. You would have to believe that Joe would have written checks to himself, or written checks by himself in a way different than he has done in his entire career using QuickBooks or his handwritten checkbook. You would have to believe that Joe would have to change his QuickBooks account habits overnight. Who the accounts were, how they were set up, adding vendors, deleting vendors. All of that activity would change overnight. All would all of a sudden change when checks are being written to and by the defendant to profit from projects that weren't even started or completed. You would have to believe that Joe wanted to or would move QuickBooks in the first place. And there is really no credible evidence of that. You would have to ignore the coincidence or believe that Joe wouldn't think to update his shipping address for QuickBooks if he did in fact place that order. But we know he didn't place that order. We know it came from the defendant's phone. You would have to believe that Joe wasn't the only one with administrator abilities to QuickBooks or had found the ability or the password to get into QuickBooks. You would have to believe the defendant in some way had the ability to access Joe's email. Because remember, what did QuickBooks do? They sent an authorization email to Joseph McStay's email address that went unanswered. That was probably a step in the covering of his tracks the defendant didn't think about. You would have to believe that the signatures on all those checks are the same, but they're not. You would have to believe that in some way that the defendant, over the course of this relationship, had always been allowed to write checks to himself and to vendors by Joseph. By a Joseph who you know was alerted to failings on projects, attendance problems, completion problems, quality problems. And in fact, Kathy Jarvis, you heard that evidence, said that she'd never known the defendant to be able to write checks on behalf of Joe before. All of those coincidences, all of those things that you would either have to accept or reject, all of them just happen to happen. Just a coincidence that they happened the day Joseph and his family drop off the face of the earth. What is the likelihood of that? What are the... Let's get Dr. Rudin in here to do the probabilistic odds of those coincidences all coming true the week of the 4th. And all of them happening in that 1 week when the defendant is cashing checks left and right for his own benefit. What are the odds? You get to February 10th.
Let me interrupt you at this point. We'll go ahead and take our noon recess a little bit early since we didn't take morning recess in the middle of arguments. So we'll take our recess till 1:30 this afternoon. Keep in mind that the admonitions previously given to you, not to form or express any opinions about the case, not to discuss the case or allow anyone to discuss the case with you or in your presence, and we'll see everyone back at 1:30.